law and peaceful coexistence. Why do you argue this?
Okay, look, Mohammed, I say this for a number of reasons. Firstly, we need to look at the context of the article, and if we're talking about infusing it with Ubuntu, it leaves us with no choice but to look at the jurisprudential landscape that we're facing at the moment. Look, we all know that we have this wonderful constitution that was supposed to usher in a new era of change and social reform. But 26 years down the line, if we look at South African society, we need to ask ourselves the fundamental question is that has things fundamentally changed? And the beauty about this, I would say beauty in inverted commas, obviously, about this case is that it lays bare to society the deep-seated jurisprudential crisis that we're facing in the courts at the moment.
Mm-hmm.
There's actually a very interesting debate that is raging between the academics, which I make reference to in my article, which I'd like to simplify for the readers. Look, we've come from a system of parliamentary sovereignty and we moved into constitutional supremacy. Now, as soon as we were ushered into this new arena of constitutional democracy, the academics have been divided into three camps. We get the constitutional optimists who believe that the Constitution has the full potential to usher in a new society and to totally transform, society with this concept of transformative constitutionalism.
Mm-hmm.
Now, what this actually means is that, look, under parliamentary sovereignty, judges were quite independent from their subjective views. Their duty was to interpret the law, and Parliament was, dished out the law and they interpreted the law. Now, under constitutional sovereignty, the role of the judge has been totally transformed. A judge in a constitutional setting is called to actually transform the law on the basis of the values of the Constitution. That is the judge's absolute duty under transformative constitutionalism.
Mm-hmm.
Now, in this particular case, we have a judge who, in the context of transformative constitutionalism, which I'd like to also critique later, who misses the opportunity of infusing neighbor law with a truly African flavor. By this, I mean that what we've inherited from the past is a Western liberal philosophy. At the moment, what we need in our jurisprudence is we need the activism of judges to infuse it with an African sovereign flavor. And this is why I say he missed the opportunity, because being an indigenous judge of African origin, the concept of Ubuntu should have flowed naturally from his lips.
Mm-hmm.
And we see that, missing from this judgment. This is why I say he misses the golden opportunity.
Certainly. Ms. Gani, talking about transformative constitutionalism and constitutional supremacy, you have now critiqued and analyzed the so-called Adhaan judgment in terms of Section 9 of the Constitution, which of course is the Equality Clause, and in terms of Section 15.1 and 15.2 of the Constitution, which guarantee the right to freedom of religion, belief, and opinion. What have you concluded about the judgment from this constitutional perspective?
Okay, look, Mohammed, in terms of this, the judge in this particular case doesn't actually engage in a constitutional analysis, because for a judge to engage in a constitutional analysis, he needs to look at the two rights and balance them in terms of Section 36 of the Constitution. So, for example, if you have the right of property, he needs to analyze the content of that right firstly, which in this case he also missed the opportunity of doing because he didn't, like Professor Kogan and for the first say, he didn't actually look at the neighbor law and follow the legal precedent in the first case. Then on the other hand, he had to look at the right of religion and opinion and freedom and analyze those and give them substance and value as well. And then put them on a scale and balance the two and see if there was some kind of reasonable limitation that could be imposed on the right to freedom in favor of the right to property. And he actually didn't engage in that balancing act, which is actually quite problematic.
Mm-hmm. Absolutely. And I was going to come to this, right? Speaking about Section 36, which is, of course, a limitation clause. Let's sort of delve into, Judge Mgandi was expected to give meaning to neighbor law in the spirit of the South African Constitution. But once again, as you have argued, he failed to weigh the competing property rights of Mr. Lowry, the applicant in the case, and right of freedom of religion and equality, on the other hand, of the madrasa. Just briefly take us through this.
Okay, look, this was meant to be a constitutional analysis where the judge was, look, in a particular instance, this case could have been decided in a number of manners. We have here an applicant who comes to court and is motivated by Islamophobia. The judge says that it's not necessary to go into a religious debate, but he summarizes the Islamic views of the applicant without giving the madrasa's views any due credence. So it's a highly imbalanced judgment in the sense that there seems to be no constitutional analysis substance given to both values of the Constitution. So it's totally absent and lacking in constitutional analysis.
Mm-hmm. Ms. Gani, the applicants, the respondents rather in this case, the madrasa, has made it clear that they are going to appeal the decision. Do you think that's going to be more effective, or for a layman's perspective, do you think petitions that are now floating around the country would be more effective?
No, absolutely. It should be taken on appeal. That's very important, and it must be overturned as well. And I think there's going to be great support for that overturning, because we've seen the voices of South Africans being heard loud and clear in the form of our brother Rivaj and so many other Muslims, Hindus, all sorts of faiths that come out in favor of the Adhaan and in favor of multiculturalism, in favor of diversity. So I think, there's great merit to going back to court and having it overturned. And, we surely don't want to set this type of tone for our country, because we're moving towards not only transformative constitutionalism, but radical transformation. And this particular judgment actually takes us, back maybe 100 years or so.
Mm-hmm. Let's pray together, South Africa. Let's pray that the richness and beauty of our united rainbow nation is always protected against the forces that seek to divide us. Beautiful words of Ms. Saadia Gani, a property lawyer in private practice. Ms. Gani, I do thank you for your time this morning, and thank you for this profound conversation.
No, Jazakallah salam. The pleasure is mine, and thank you. And thank you to the listeners for listening in. Jazakallah.
Thank you. Assalamu alaikum.
Wa alaikum assalam.
What an engaging conversation that was. And this is why I appreciate academics, especially legal academics, for their headstrong critique. See, it seemingly appears to be easy to sit in one's office, to sit in one's study at home and critique court judgments. But it is fundamental in a constitutional democracy such as ours to hold those in power to account. As goes the saying, who will guard the guardians? Who will watch the watchmen? And as Chief Justice Mogoeng had once mentioned, it can only be in a dysfunctional constitutional democracy that one wouldn't come across criticism of the three arms of government, namely the executive, the legislature, and the judiciary. It is an indication that some people are doing their job. Having said this, it is the end of the Friday edition of News and Views. Until Monday, from myself and the entire production team, goodbye, assalamu alaikum, and happy weekend. ولا تتركني يا إلهي أنت ربي